All right, welcome to The Explainer. Today, we are diving into a really critical chapter for your LSO paralegal exam. We're talking about Chapter 8, Fees and Disbursements. And let me tell you, getting a handle on these rules, it's not just about passing the test. This stuff is absolutely non-negotiable for your entire career.
So this question right here, it really gets to the heart of it all. See, this whole chapter isn't just about how you bill for your time. It's about ethics, it's about trust, and it's all about your professional duties. And you can bet the exam is specifically designed to see if you really get that.
Okay, let's kick things off with the big picture. What is this chapter really about? And maybe more importantly for you right now, why does the Law Society just love to put this stuff on the exam? Well, it's because this is a cornerstone of professional responsibility.
At its core, this whole thing is about two key ideas: being transparent and protecting your client. Think about it. It covers everything from that very first chat about costs all the way to how you handle their money in a trust account. And the exam? It's going to throw practical scenarios at you to make sure you're someone who can absolutely be trusted with a client's money.
All right, now for what I think is the most useful part of your prep: spotting the triggers. These are the little details you'll see in a multiple-choice question that should set off alarm bells in your head, screaming, hey, this is a fees and disbursements issue.
Okay, so here's the first big one. The second you see a question about a new client coming on board, your brain should immediately jump to initial disclosure, right? Have you talked about fees? Is there a written retainer agreement? Is there an engagement letter? That is always ground zero.
Here's another classic trigger. A question describes a client who says, "Hey, I can't afford to pay you up front." Boom. That is a massive flag for contingency fee agreements, or CFAs. They're testing you on when you can use them, what forms you have to use, and all the specific things you need to disclose.
And this one's huge. You read a scenario where a client was sent to you by, say, a lawyer or an accountant, your mind has to go directly to two things: referral fees and fee splitting. The exam is absolutely going to check if you know the critical difference between the two and the super strict rules that apply to each.
Okay, let's dig into the absolute bedrock of this chapter. These are the core rules, the non-negotiables. You really have to know these cold to have any shot at getting these questions right.
Okay, look closely here because this is a fundamental difference. Fees? That's what you get paid for your time, for your expertise. That's your profit. But disbursements are totally different. That's just you getting paid back for money you spent on the client's behalf. And the number one rule here is you can never, ever mark up a disbursement or make a profit on it. That's a huge deal. So every single fee you charge has to be fair and reasonable. And the exam loves to test this. They'll give you a scenario and basically ask, is this fee okay? So what do? You use this list as a mental checklist. You ask yourself, okay, how much time did it take? Was this a really tough case? Did we get a killer result for the client? All of these factors together are what determine if a fee is reasonable.
All right, this is so important. A money retainer is not your money. I'll say it again, it is not your money. It's the client's money, and it stays their money until you have actually earned it and billed for it. And that is exactly why it must go directly into your trust account. No exceptions. It has to live there, totally separate from your business's day-to-day cash.
And the order you do things in here is everything. It's not a suggestion, it's a mandatory 3-step process. Step 1, you do the work. Step 2, you send the bill. And only then, Step 3, you move the money. If you get that sequence wrong, even if it's an honest mistake, that's considered misappropriation of trust funds. And that is, without a doubt, one of the most serious things you can be accused of.
Okay, so you've got the core rules down. Awesome. Now let's get into the exceptions, because this is where the exam gets tricky. These are the little details that separate the people who just know the basics from the people who are really going to ace the section.
So the rule is pretty simple. You can't split your legal fees with someone who isn't a licensee, period. But there is one very narrow exception, and that's if you're part of a formal multidiscipline practice, an MDP. So that informal deal you have with your accountant buddy to kick them a piece of the fee for sending you work, nope, that is totally prohibited and it's professional misconduct.
Now, this is a really important rule tied to access to justice. If you're working through an approved civil society organization, or CSO, the services you provide to the client have to be 100% free. You can't charge them a fee, not directly, not indirectly. Now, you might be able to get reimbursed for some disbursements, but only if you've been super clear about that up front and the client has agreed to it.
All right, pay attention, because this section is where you can really pick up some extra marks. We're going to talk about the common exam traps, the tricky spots where people get confused, mix up two similar ideas, and end up choosing the wrong answer.
Okay, this is a huge one. Do not, I repeat, do not mix up fee splitting and referral fees. They sound similar, but they're completely different animals. Think of it this way. Fee splitting is for collaboration. Two licensees work on a file and divide the fee. A referral fee is for acquisition. You're paying someone just for sending you the client. And because they're different, they have totally different rules, different caps on the money, and different forms you have to use.
Oh, this is a classic ethics trap they love to use. Imagine this. Your client hasn't paid you. Their hearing is literally tomorrow. Can you just walk away? Well, the answer isn't about the money. Your number one duty is to not cause serious prejudice to your client. So if bailing on them the night before a hearing is going to screw up their case, you might just have to suck it up and continue even if you haven't been paid.
Watch out for the math on contingency fee questions. Here's the golden rule you need to remember. Your fee can never be more than what the client actually walks away with. After you subtract all the disbursements and taxes, the client's take-home amount has to be equal to or greater than your fee. So even if your 30% calculation is technically right, this ultimate rule of fairness trumps it. The client has to get at least as much as you do.
So what's the bottom line here? What actually happens if you mess this stuff up? Let me be clear. This isn't a little slap on the wrist. The consequences are massive. We're talking about things that can affect your money, your reputation, and even your ability to stay in the profession.
Look, if you want the fastest way to lose your paralegal license, mismanaging client money is probably it. You're almost guaranteed of finding a professional misconduct. If you touch trust money improperly, that's misappropriation. We're talking license suspension, we're talking revocation, we're talking being forced to pay back every single dime. The Law Society does not mess around when it comes to financial integrity.
Okay, let's bring this all home. I want to boil down everything we've covered, all the rules, all the triggers, all the traps, into one single question you should always have in the back of your mind. This isn't just for the exam, this is for your whole career.
This is the question. If you can look at any bill you send out and honestly answer yes to this, then you are on solid ground. Because this one question really captures the spirit of every single rule in this chapter. It's about more than just following the rules. It's about acting with real integrity, the kind the public and the Law Society demand from you. And that's a wrap on our breakdown of the absolute essentials for fees and disbursements. Keep those triggers and core rules in mind, and you are going to be in great shape for the exam. Good luck with your studies, and we'll catch you in the next explainer.